Hey, y'all. Thank you so much for joining us for this life and legacy planning for families, so estate planning for young families. My name is Trish Butcher, and I am an attorney with Arch Legacy Firm in Athens, Georgia. And we serve clients all over Georgia, not just Athens, but our office here is here in Athens. And again, thank you for joining us, and let's go ahead and jump in. I know that your time's very valuable, and I really do appreciate y'all taking the time to be here today. If you hang around towards the end of this presentation, there will be a complimentary one-on-one meeting with me to talk about you and the people you love the most and how you can protect them. So there will be more information following the presentation, and there may even be a discount on your estate planning if you hang around. So make sure you hang around to the end of the presentation so you can learn more about that. So you're in the right place if you have someone or something you care about and want to protect. You don't know who to name for guardians. A lot of people don't know who to name for guardians or even where to start. You're nervous about meeting with an attorney, or again, you just don't even know where to start with estate planning. Estate planning is kind of an interesting topic because it's not something that we really sit around the dinner table talking about. It's kind of morbid. It's not like we're going to be like, honey, so what does happen if one of us passes away? But the fact of the matter is that there's one truth in life, and it is that we do all eventually pass away. So estate planning is about planning ahead to protect our loved ones. On that note is, the reality is estate planning is not about us. It's about the people that we love the most. Your loved ones will know at the end of the day whether you lived up to your promise and actually took care of it. So it is one of the ultimate gifts that you can give to your family. And we'll go into that a little bit more as we go along. So before I get started, I do want to tell you a little bit more about me and my family. Again, my name's Trish. I grew up in Athens, Georgia. I went to the University of Georgia undergrad before going on Emory Law School. I am super lucky, and most of my family does still live super close to me. In fact, a lot of us live within like a mile radius of each other. My brother's the only one who has kind of escaped the family little net of Athens, and he actually lives in Denver. But I'm not gonna lie, I don't mind it because then I get to visit him in Denver often. So my husband Andy and I live here with our son Max, and Max features a lot into my stories about estate planning and why I do what I do. We also have a cat Whiskey and a dog Woodford, more commonly referred to as Boo Boo and Woody. And they also feature into like my Instagram and my social media quite a bit. So we do love our fur babies. So again, I graduated from UGA in 2010. I graduated from Emory Law School in 2013. I worked for the Medical Association of Georgia in Atlanta for several years before deciding that I needed to take a step back from number one, having a boss, and number two, living in Atlanta. My husband and I wanted to start a family, so we decided to move back to Athens. And in the very beginning of 2020, I decided that I wanted to open my own firm, which is something I never thought I was going to do. So I opened Arch Legacy Firm, originally named Butcher Health Law, but we rebranded this year. So I opened Arch Legacy Firm, and then I was lucky enough to convince my sister Stephanie to come on board with me. So right now, the team consists of me and her, and I'm the attorney. She does basically pretty much everything else. So she's a huge asset to have on my team. And I'm so thankful that I get to work with my family to help other families and help educate families on how they can help their families. So I have a few reasons that are my why, I guess, for why I wanted to open this firm and why I wanted to dive into estate planning. I did take a 6-month master course in estate planning when I decided to open my firm. I am a certified personal family lawyer. I'm the only certified personal family lawyer in Athens, in the Athens area. So I take that very seriously. And again, I love working with families, partly because of my son and my family. I knew after having him that I wanted to be able to protect him. And when I looked around at other attorneys and other options, all of these more traditional firms, law firms, I wasn't very enthusiastic about what I was finding. It just seemed so antiquated. Like nothing had really changed in the past 40 years. It was a will, naming guardians. They didn't really get to know your family and nothing seemed personalized. So I wasn't exactly enthusiastic about that. And I knew that I wanted to do something a little bit more for my son. On top of that, a few years back, I actually saw the epic failure of an estate plan, and that was my grandmother's estate. So, my grandmother passed away when I was graduating college. Her husband, my grandfather, but technically my step grandfather, passed away about 5 years later. And he did have two children from a previous marriage, and then my grandmother had my dad. So, after my grandfather passed away, I think we were all pretty shocked to find out that this very extensive, huge estate plan that they had in place was not going to work at all. So they had spent thousands and thousands and thousands of dollars on an estate plan working with attorneys in Florida. And lo and behold, my dad ended up in court and conflict for 4 years after my grandfather passed away. So this was huge. It was so stressful on my family. It was so expensive. It lasted forever, and the my grandfather's children sued the estate time after time after time again, all with zero legit reason to do it. So, y'all, when an estate is in probate, it's open. That means that anybody can come in, and no matter how ludicrous the charges, they can sit there and sue the estate over and over again and create so much stress. They won not one thing. All of their claims had zero merit, but yet they were able to draw out the probate process for 4 years for my dad and my family. And that was extremely stressful on all of us. So, one last thing, one last reason that I love what I do and am very passionate about it is my dad's will. My dad is still alive, thankfully. But when I started really getting into this and digging a little deeper into estate planning, I looked at what my dad's plan was. And I was amazed that my dad only had a will. He had gone to a very well known attorney here in Athens, a big law firm. He was at the time single, over 60, and a smoker. And he had, assets. He's not a billionaire, but he had assets. And he left that lawyer's office with a will only, no incapacity documents like power of attorney, healthcare power of attorney, or advanced healthcare directive. Who does he want to take care of him if he's incapacitated in the hospital? And the will simply left his estate split 3 ways between me, my brother, and my sister. So basically, the will accomplished exactly what the law would have accomplished, which is just absolutely insane for me. So he literally paid for nothing. He paid for the law. And to me, that just, it blew my mind that attorneys offer this and that they charge for it. Is this not malpractice? I mean, what is going on here? After seeing these two examples of estate planning, I knew that I wanted to dive in and really help families. I wanted to get to know them, learn their families, learn their goals, and help create a comprehensive and personalized estate plan that actually works for their family. So, one question that I always have for people is that do you have people that you love and want to protect from court and conflict? If the answer is yes, then you probably need to look into estate planning, because otherwise, no matter how straightforward or simple you think the probate process would be after you pass away, it almost never is. So, what are we going to learn today? We're going to learn how estate planning can affect your family by looking at the Smith family. And I'm trigger warning, the Smith family is about to have a couple of really bad days, because at the end of the day, this is estate planning, so it does have that level of morbidity. So let's look at the Smith family and follow along with them and look at the different options that they have as their life moves on. So this is the Smith family. We have John, Samantha, John Jr., and Allison. They're just your typical American family. And like I mentioned, they're about to have some really rough times up ahead. So John has to go on a trip and Samantha has to go to a meeting at work. So they call in a babysitter. The babysitter comes in. The kids are really excited. This has been their babysitter their entire life. They're very excited about it. So when Samantha is on her way to her work meeting, she gets an email saying that the meeting had been postponed. So she decides to hit the gym up first. She puts her purse into her locker, locks it, and gets on the treadmill. But while she's on the treadmill, unfortunately, she has an aneurysm and passes away. Meanwhile, the babysitter's calling and calling and calling, and she's not getting a hold of anybody. And Samantha's purse is actually locked up in that locker. So there's not even anybody that could answer it instead. So unfortunately, there's no way of the babysitter knowing what's happened or what to do. And meanwhile, the dad is on a work trip out of the country. So result one, no estate planning. The babysitter would really feel that there was no other option but to call the police at this point when she couldn't get a hold of the mom. The police have no option but to take the children into protective custody while the dad tries to get a plane flight back home to take the kids. Unfortunately, this is the reality that kids will be taken into protective custody until a close family member or a permanent guardian can get there to take over. Result two, simple estate planning. If they just had a will, would any of this change? And no. Unfortunately, the reality is that most likely this would not have changed. The children would still have been taken into protective custody, and the dad would have still been stuck trying to get a plane flight home in order to get his kids out of protective custody. You can imagine how traumatic this would be on children. But the fact of the matter is that your babysitter, unless very closely related to you, really has no authority to legally keep your children. So if you don't come home, they have no option but to call the police. So at my firm, we do something called a kids protection plan. And one of the things that we do in this kids protection plan is that we actually name emergency guardians. These are friends or family who live nearby who can step in and keep your kids legally in the event of an emergency. And this is so, so important because often our family doesn't live close by, or our permanent guardians don't live close by, or people that we trust and love don't live close by. And someone's got to be able to get there ASAP as quickly as possible to take care of your kids. And that's why emergency guardians are so important. Guardianship is equally about what happens in an emergency as it is about who will raise your children if you can't. So it's really important to remember that. And again, this was just something that I was not really seeing available at any of the more traditional law firms. So result three, what would have happened if she had advanced estate planning? So they would have had these emergency guardians. The babysitter would have had instructions to call the emergency guardian before the police. They could have come there with the legal proof, kept the children until dad gets home, and then the dad and the children get to mourn, grieve, and recover together without any traumatic experiences for the kids beyond losing their mom, which is traumatic enough. So it saves them from having to go into protective custody. The emergency guardian steps in and is able to keep them. It's someone they know and trust and love until the dad can get there. There's no protective custody. No police are necessary to keep those kids safe. So unfortunately, as I mentioned, things only get worse. John has learned, and he does create an estate plan, and he takes out life insurance. And then he gets in a car accident. So what happens now that these poor kids have lost both of their parents? So the children's move in with their permanent guardians and they can begin the recovering process. But what happens to all of those assets, that life insurance policy that he took out, all of his retirement plans, all of the house, all of the assets that they have? What happens since the children are minors? So one thing you want to consider first is naming permanent guardians. And there are special things you want to consider. It's not always the person that's the closest related to you. It might even really be good friends or cousins. It doesn't have to be siblings. And this is where a lot of people have trouble picking out a permanent guardian for their kids, because of course, we really just want to do it ourselves. We don't want to entrust anybody else. But when we need to, it's important to have these people named so that you get to pick your permanent guardians and not a judge. So some of the things you might want to consider when thinking about guardians are values, spiritual beliefs, financial approaches, location, similar child rearing ideologies, and access to loved ones. These are all really important things to consider when thinking of guardians that you would like to keep your kids. So, do you know who you would name as your legal guardian for your children? If not, it's not a big deal. I actually work with all of my clients to help them figure this out. I give them helpful tips. I help them kind of think through it, and we work through the process together. And we're going to actually name a successive list. So we'll start with your number one options, and then we'll go from there because we want to make sure that your kids are protected no matter what. And we do plan for the worst, but hope for the best always. So, result one, if there had just been simple estate planning, John and Allison would have John Jr. would have inherited their money at 18. So, if kids inherit as minors, the judge will actually throw everything, including life insurance and retirement accounts, into the probate estate. And then they'll assign a financial conservator to watch over this money until the kids turn 18. And then they will get a lump sum check of whatever's left over. As you can imagine, not the best option. So as you could see here, John and Allison, what do? They go spend it on fancy cars, jewelry. I mean, honestly, 18, they might go have a little more fun in college than most kids are able to have. So this is not the best option. We do not want our kids to be inheriting lump sum of money at 18. So before we can go on about that, let's really dive into what is probate. So a lot of people don't really understand exactly what probate is. Probate is simply the court process that supervises the process for distributing assets after a person passes away. So probate is the court supervised process for distributing assets after a person passes away. And a judge oversees this, and it is timely, it is costly, and basically it takes a long time. So what does a will do? A will tells the judge how to distribute your assets. It is a legal directive for the probate process, aka your will does not avoid the probate. It is simply a directive that tells the judge how you want your assets distributed, and it will not control of your assets or protect you from probate. So that's super, super, super important to remember. Having a will equals probate. Your private matters become public information. Wills are extremely easy to contest. Court is involved in every step of the process, and there's no distribution until judge orders it. So attorney's fees and court costs will add up during that process. Multiple probates if assets are owned in 2+ states, and the process typically takes over 6 months to complete. In Georgia, it's typically 6 to 12 months. However, since COVID, it's actually more around a year to 2 years because the court is still very backed up and we don't know when that's going to right itself. So probate is public. It's extremely lengthy. Your beneficiaries will have no access to any of your assets as long as they're tied up in probate. It will be multiple probates if you own property in multiple states, and the process takes a very long time. So AKA probate is extremely stressful, even if it's not contested, and having a will does not avoid it. So another question for you is, have you ever experienced probate process with someone close to you? And if you have, you do know that even for simple probate processes, it's stressful and it takes a long time and it costs a lot of money. And we like to help our clients avoid the probate process. So how do the kids inherit with just a will? So as I mentioned, a judge would appoint a financial conservator because minor children cannot inherit. So all assets, including retirement policies and life insurance, will be thrown into probate for that financial conservator to manage until they turn 18, when they will get a lump sum. And financial conservators, by the way, cost even extra money. Who will the judge choose as the children's financial conservator? We have no idea. So all the more reason that we work with our clients to help them avoid probate. When will the children receive their inheritance outright with no protections or guidance? As I mentioned, it's at 18 years old. So let's do something better for the Smith family. Result number two, the children receive their inheritance in a trust. So instead of getting their money outright at 18, their parents had left them a life and legacy interview, leaving behind their values and guidance about how they wanted their kids to be raised. They left behind financial values, and they asked that the money be used to support them through education and then finding a job and getting out on their own. And then they stipulated how the money would be passed to their kids after they passed away. So there's different ways that this can be done. But let's dive into a living trust a little bit more. What is a living trust? Not many people have heard of revocable living trust. And I'm here to kind of help shed a little more light on this probate avoidance tool. So a trust is a will substitute, but there is no probate. And that is because when you pass away, technically you do not own any of your assets. Your trust does instead. So your share of jointly owned assets all go into your trust. Beneficiary designations are updated to your trust. So life insurance, those retirement policies, instead of being thrown into probate for your kids, instead they all go into your trust. And all of your trust assets are immediately available for your loved ones. No court and judge required, period. So let's go back for a second. So a living trust, I mentioned that you retitle things into the name of your trust. So how does this affect all of your assets and your property while you're still alive? Well, the good news is that it really has very little impact on your day-to-day life. Once you have funded your trust, which simply means retitle the things that you already own into your trust, like your house, bank accounts, and name the trust as the beneficiary designation of your life insurance and retirement accounts. Once you've done this, there's really nothing that you have to do except continue to add those assets to it as you gain them. So while you're still living, you're the grantor and the trustee of your trust. That means that you still have the ability to do anything you want to do with this trust. It's basically just a bucket that holds your assets for you so that when you pass away, you can name a successor trustee who will then immediately step in and administer your estate and make sure that nothing gets neglected in the interim. So no judge, no probate attorney, no court fees, no lengthy probate process. Someone you trust and you name is going to step in and take care of your assets and your family immediately after you pass away. So living trusts are extremely beneficial for anybody who has any assets. I often tell my clients, you have two options. A will is definitely better than nothing. And the judge, it absolutely, if done properly and is legally effective and not vague or whatever, a judge will abide by it and the assets will be split the way you want them between your beneficiaries. But if you would like to save your family the trouble of probate to make it as easy as possible for them while they're grieving for you, a living trust is going to be the better choice because it's just a way of making sure that your family can avoid probate. You can get more creative with living trusts. You get to decide how your family inherits instead of it just at 18. You can make sure that your kids inherit when and how you want them to. And trusts also provide a lot more options for estate tax planning or an advanced asset protection. So trusts are a much better way to go if you're worried about avoiding that probate process for your family. So some other considerations that we need to think about with estate planning is incapacity. So even before you pass away, estate planning does actually apply to you. With all of our plans, we create a power of attorney, a healthcare power of attorney, and an advanced healthcare directive / living will for our clients. So even our base plan is going to include wills for both spouses, power of attorneys, healthcare power of attorneys, and advanced healthcare directives for both spouses. The reason we do this is because we want to make sure that your wishes are followed even while you're incapacitated, that your family is still taken care of while you're incapacitated, that your bills get paid, that your house mortgage gets paid, that your taxes get paid, that life continues to move on so that when you recover, or if you don't, things will be in order and ready to go, and everything's being handled by people that you've named and that you trust, and that your family doesn't have to go petition a judge in order to get the ability to do this for you. So incapacity documents are just as important as the documents, the wills, the living trust, the documents that step in after you pass away. So lesson number one, our children are our most important assets. So I don't care if you don't have hundreds of thousands of dollars yet in the bank or in investment accounts. If you have children, you have assets, and it's really important that we take care of them. So even if you don't own a house yet, or you don't have a lot of assets yet, maybe that's when the will plan does fit really well for your family. But it includes that kids protection plan, which is so important for minor children, because again, guardianship is equally about what happens in an emergency as it is about who raises your children long term. So with our kids protection plan, we make sure that your kids have emergency guardians, permanent guardians, and minor medical power of attorneys so that they are protected no matter what. Lesson number two, wills do not avoid probate. This is a big myth and a big misunderstanding when it comes to estate planning. If you have a will, your estate will still go through probate, and probate is a very long, public, and costly process. Lesson number three is something that I haven't really touched on that much yet, but I do want to bring it up. A review of all of your assets must be a part of your estate planning conversation. A document alone is not enough to protect you. In fact, there is over $1 billion in the Georgia Unclaimed Properties Department because of this very thing. Families, executors, trustees, whatever it may be, don't have access to those assets, or they don't even know they exist. And so they just fall through the cracks. And we want to make sure that your family has access and knows exactly what's there when you pass away, and that your trustee or executor has it as easy as possible to gather these assets and pass them on to your family. So, as I've mentioned a few times, Arch Legacy Firm is a little bit different than that traditional attorney experience. So with the traditional experience, you're going to have hourly fees. You're going to have knee-jerk response to problems, and families are just a transaction. They do one size fits all, fill in the blank wills for every family and experience. And to us, that is just not the way we want to work with our clients. So instead, we have flat fees agreed to in advance. So we have packages that all of our clients get to see before they engage us and pick the package that best fits their goals and their family needs. We plan ahead for families to avoid problems. We name multiple guardians, multiple emergency guardians, multiple power of attorneys, multiple trustees, because life is an ever turning circle. It doesn't stop when you make these choices in the first place. It continues on. So we want to make sure we've planned ahead for all contingencies that we can at the time. It's relationship based. I like to create a very personal relationship with my clients. Estate planning is personal. It's morbid. It's about your family. It's about your life. It's about what happens when you're no longer there. So I want my clients to know that I have their back, that I know their family, and that we're going to actually protect them in case anything happens to them. And all of our plans are created specifically for you. No fill in the blank, one size fits all document or will that you can do online. Because honestly, if that's what you're looking for, you can find that online. You don't even need to pay an attorney to do that, because it's really not going to be any different. So my promise to you is that your estate plan will leave no stone unturned and will give you peace of mind, knowing that your loved ones and assets are going to be kept out of court and conflict, and that we're going to work with you to pass on your legacy, not just your property. So a little bit more about my process. Our first initial meeting with clients is called the Family Wealth Planning Session. Before this meeting, we have our potential clients fill out homework telling us a little bit more about their family, their assets, their goals, and where exactly they are. From the Family Wealth Planning Session, at the end of it, we'll go over all of my packages that I offer, and we'll find the best plan that fits their needs. Now, The family wealth planning session is no obligation meeting. So if you leave the meeting and the only thing you leave with is a little bit more education about estate planning and a little bit more understanding about it, and you're a little bit more financially organized after doing our homework, that's totally fine. You don't have to retain me. I'm not going to be the best fit for everybody. But if you do choose to move forward with me, we will pick the package that best fits your family. We'll set a design meeting. So I don't have this included because it's really about a 30-minute, 30-minute meeting. And it's going to be in between that signing ceremony about a week after the family wealth planning session. And this is where we sit down and we just name, who do you want to be your guardians for your kids? Who do you want to be your power of attorney, your trustees, your healthcare power of attorney? And I do give my clients homework so that they can sit down with their spouse and think about those things ahead of time versus having to just have it like think of it all on the spot with an attorney sitting there. So I like to make them as comfortable as possible and help y'all make those decisions even before the meeting. And then, of course, I walk through it with them and make sure that all my clients know exactly what these roles are and why it's good to have certain people in these roles. So after the design meeting, we set a signing meeting for about a month out. The signing meeting does have to be in person. It's our only meeting that has to be in person, but it's where we sit down, we review all of your documents, I answer any questions, I make sure that you fully understand what you're signing, and then we sign, witness, and notarize. So at this point, your documents are 100% effective, but we do keep them because we scan them into our system. We keep a copy in our secure database, as well as giving all of our clients a USB flash drive as well. The final meeting is called a binder delivery meeting. It's where we give you your binder. We just quickly go through everything, make sure you know where everything is. We give you your USB flash drive. And then we do offer something a little bit more special because, like I've mentioned, legacy is just as important as assets. So we actually offer a life and legacy interview for all of our clients. And this interview is just where I sit down, I film them. So it's not in everybody's comfort zone, but I ask questions about your childhood, how y'all met, how the husband proposed, how your goals, your values, your beliefs for your family. And then we go from there. So it's usually about a 30-minute interview. I kind of customize it to my clients. So I don't just use like the same questions over and over again. I like to make sure that it's customized to my clients. And if you have created this video, y'all imagine how special this would be for your kids if anything happened to you. I know that I wish I had it of my grandfather. I did ask him so many questions before he passed away, but I had so many more, and I would have really loved to learn more about his childhood. So it's really something very special we offer our clients. Again, it is optional. It's not required. I'm not going to make anybody go out of their comfort zone that much if they don't want to. So our flat rate packages do start at $2,000 per couple, $1,500 per individual. And that's for the will plan that again includes wills, power of attorneys, healthcare power of attorneys, advanced healthcare directives, and that kids protection plan. We bill all of our clients half up front, half after the signing meeting, so about a month apart. And we invoice with QuickBooks, so our clients can pay however they want to pay. I'm extremely transparent with my prices. I do like to go over all of my prices at the end of the family wealth planning session once people get a really good understanding of what everything means and the value in everything. So I will go into more detail about pricing at that family wealth planning session before my clients choose to engage me. So if you're not sure about the pricing, don't worry. You can still schedule a family wealth planning session and we'll go over it then. So the biggest risk to your family is procrastination. It is so easy to shove estate planning to the back burner, but I want to make it easy for you and your loved ones. So as a gift to all of y'all, if you've made it this far in this webinar, I'd like to offer you a $250 discount on your personalized estate plan when you book your family wealth planning session in the next 7 days. So again, $250 discount. You do have to book your family wealth planning session within 7 days after watching this webinar. And please shoot me an email and tell me that you have watched the webinar and that you're booking a family wealth planning session. It's just the easiest way for me to stay organized. I want to make sure that my clients that qualify for this discount actually get it. So yes, this is my gift to y'all. Thank you again for taking the time out of your day to watch this webinar. If you do have young kids, trust me, I know how hard it is to find time to learn about something like this, especially something that a lot of us push to the back burner because it is extremely hard to think about passing away. So thank you again. Stephanie and I are so excited about potentially working with y'all. So if you'd like to schedule your complimentary family wealth planning session, you can do so at www.archlegacyfirm.com/FWP-schedule. So the link's right here, but again, it's www.archlegacyfirm.com/FWP family wealth planning schedule. And if you have any questions, or if you'd like to schedule a consultation, you can do so. So to schedule a consultation, again, go to archlegacyfirm.com/schedule. And you can schedule a consultation, or you can give me a call or send me an email at trish@archlegacyfirm.com. So again, that's trish@archlegacyfirm.com. I'm always happy to answer questions. If you don't find a time on my calendar that fits the time that best works for you and your spouse, please feel free to give me an email or give me a call, and I'm happy to work with you to find a time. Again, Stephanie and I, we really love working with families. We love working with all different types of families. It has been so much fun meeting everyone and designing customized and personalized plans that will actually keep their family out of court and conflict and give them peace of mind. I hope you all have a fabulous day. Please don't hesitate to reach out to me if you have any questions. And thank you so much for hanging around for this webinar.